What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast. And we are on the eve of Karen Read trial number 2 starting. So I brought my dad back in to talk about the last pre-trial hearing, the orders from Judge Cannoni, how they're going to affect trial number 2, and what we're still trying to decipher what some of them even mean, because some things happen and she's going to allow some things in that we don't even think would be allowed in potentially in Florida or in federal court. So we'll talk about what those are and whether or not they're good for the defense or bad for the defense. And we're going to get into some of the good arguments made by the lawyers, some of the bad arguments made by the lawyers, and jump into what we're looking forward to on trial number 2, especially starting with opening statements tomorrow. Hello.
Hello.
Before we get into the arguments and the orders in the final pretrial hearing, we have 9 men and 9 women, 18 jurors total for a 6-ish week trial. It took twice as long as it did the first time around. Any final thoughts on jury selection? The jury, they ended up with, being split down the middle, which is very unusual. I don't know if I've ever had a complete perfect split down the middle. And they took 6 alternates, not just 4. Any thoughts you have on that?
No, I mean, obviously, we've discussed it before. 18 is a reasonable number in this case because of the history of the case and what they lost last time, the number of jurors they lost. So it was a reasonable amount. You're right, that split is kind of unusual, that we had an even split of men and women. Um, it's a 6, I think 6 is a minimum, 6-week
Yeah.
trial. So, they're dedicated to it, and, we're rolling. As we'll see in these discovery issues when we talk about the hearings, when this trial starts and when they are going to get all the discovery is going to be kind of interesting too.
Yeah, I was thinking about the 6 week and how they kind of agreed to that, yet additional experts keep getting added. They're still trying to strike certain witnesses that are not going to be 30-minute witnesses. When you have these experts testify, it's a couple hours here, a couple hours there, and she keeps allowing everybody to testify. So it's like, is this trial getting longer, or did we plan for all of this when we said 6 weeks? Who knows? All right, so let's go ahead and pull up the order, and this is going to help just kind of guide us and give us some structure to our discussion and your thoughts and feelings on what happened in this final hearing. By the way, for anybody that doesn't know, this final pretrial hearing and conference is kind of all of the things that are left over that the judge has not decided on. Some of them can affect opening statements day one, so you really have to get the information in. Almost every trial, we have some things that continue into the trial itself, right? So it's not that unusual that stuff is still happening even after the trial starts.
Right. Oh, absolutely. Now, it is a little unusual that they actually are going to get stuff after they do opening statements, which sounds like may happen in this case.
It feels like it's definitely going to happen, but that happens to us all the
Yeah.
time. Like, especially
Yeah.
if the police come up with something new, or they talk to somebody, or there's an additional conversation they had, or a supplemental report they haven't turned over. That happens all the time. Or like in some civil cases, their expert has updated their opinion. They wanted to do an update depot with our client before the trial starts. That type of stuff happens kind of throughout the trial. I've deposed expert witnesses during trial as the first deposition that I've ever taken of that expert. So it's
But,
like
but
stuff
those
happens
are
like that.
but those are civil cases. When you're talking about deposing an expert after a trial starts,
I've
uh,
had, but in criminal cases, I've absolutely had the state give me supplemental reports
oh, oh,
from police officers.
oh, absolutely. But you
Yeah,
don't see it with experts.
no, I mean the law enforcement. I mean, the state doesn't have as many experts as we do in civil cases usually, or
Right.
it's the same expert they always have, and we kind of know what they're going to say. But no, I'm talking. There's stuff that happens after trial starts.
Yes, stuff
That's all.
happens. Yes.
Yeah. And it seems like some of what they're going to get after trial starts is similar to a police report or supplemental report, but we'll get into it. Okay, let's start with the first one. I'm going to get your take. I've already given a lot of my takes on prior videos, so we'll kind of discuss through your takes. The first one is the defendant's motion for reconsideration of a portion of the February 18th, 2025 order denying defendant's motion to compel production of a forensically sound copy of the January 29, 22 Sallyport video surveillance footage.
Okay. This one, honestly, I don't understand why it was denied. It is There is no reason why they can't get an original copy with all the metadata, and I'm sure your listeners are more familiar with metadata than I am, with all the metadata that is contained on a video, um, and Brennan just was talking in circles when he was responding to this, because he was saying, well, they came and looked at I think it was a DVR, but the DVR was blank. And, they want to make this, quote, forensic copy, which we know is called a mirror image a lot of times. And it has the metadata. It has a lot of, excuse me?
Be careful using that terminology, a mirror image. People are going to have flashbacks
Oh,
to the
okay.
inverted video, but I know what you mean.
Right.
A direct copy.
Experts call it, that's what experts call when they come in and they take an exact uh, picture
Copy.
of whatever it is that they're trying to download. And they also mentioned, and they're correct, every time you re-download or every time you do something with a particular video or any kind of data, it adds data to it. It adds metadata, it adds all sorts of things, and it changes the background information that you actually don't see unless you're an expert and get into it. I just don't understand why they can't either give them or won't let their expert come in and make a forensic copy or do whatever they want, whatever kind of copy they want in order to do the testing. This one I don't understand, and I certainly didn't understand Brennan's reasoning when he gave his arguments.
Yeah. Yeah.
What
I
harm would it do?
say that again.
What harm would it do?
Yeah. It feels like they're hiding something, which it's like everything is so messed up when it comes to Sallyport anyways, but it's par for the course. I wasn't really that surprised by it. All right. The next one was the Commonwealth's renewed motion to exclude testimony of Garrett Wing.
Okay, now I guess we can kind of put the dog bite arguments together.
Sure. Okay. The next one is, yeah, the
Right.
next one is the James Crosby, who's the Commonwealth's expert. So she is going to allow Garrett Wing, the defense expert, to testify. She's going to allow Dr. Crosby to testify, but not to exclude Chloe's bite based on the measurements. But she is going to let him, and this was one of the things I kind of had a problem with. She is going to let him testify about Chloe and the measurements he took of Chloe's mouth, which is crazy to me because a juror knows what 6 inches looks like. They're going to be doing their own math on John O'Keefe's, the injuries on John O'Keefe's arms. But what was your thought with the arguments on both of these experts and where the judge ended up landing?
Well, I got to go back historically. I've actually tried cases before they actually found out bite marks didn't actually identify who actually did the bite, where FBI used to come in and say, "This is the person who did the bite. We can definitely identify. It's like a fingerprint. One set of teeth. Yes, that's the guy." Then they did all this work on it, all this study, and they found out that was just junk science, that there really isn't a way to take a bite mark and identify for certainty this bite came from this person. And that was humans. And the study that were cited and were arguments in here were the human study. Well, if you can't do it for a human, you certainly can't do it for a dog. And so they're right in the argument is you cannot do this. Brennan's argument that we're not trying to include, but we're trying to exclude Cleo was also a ridiculous argument. It was just bogus. It was him, dancing on the head of a pin, trying to make an argument that really makes no sense. If you can't include somebody, you can't exclude them either. So that was a ridiculous argument, and the judge didn't buy that. So the judge is allowing whether it's a dog or not. But you're right about the measurements but again, measurements are a fine thing. That's actual. That's real. You measure a bite. That's a real measurement. It's not false, but then you're going to have the jury being detectives, and they're going to take that measurement and take a look at the scratches on the victim.
So I want to respond back and forth because I think this is an interesting discussion. I agree they're finite, but I can't put an expert up there to say what's the measurement of my hand because it's not relevant. It's not probative. How are the measurements of Chloe's mouth probative or relevant if we are not going to use them to exclude her or include her based on the injuries to John O'Keefe's arm? They're completely irrelevant.
Oh no, I understand your argument, and I buy your argument. Your argument's the one, if I was the judge, that I would buy. What I'm saying is, what she's doing here is trying to say, yes, you can't say yes, this is Chloe's bite, but hey, 2 inches is 2 inches, 6 inches is 6 inches. You can measure Chloe's mouth and give it to the jury and let the jury be detectives. I don't think you should, because that really is speculation, and that really is creating evidence outside of the courtroom. Because you really think about it, what's happening is the jury is then going to be testifying within the jury room when they're making their decision, saying, look, let's be detectives and create our own evidence. Let's take a ruler and take a look. But on the other hand, the picture, is the picture an accurate reflection? Is it blown up? Is it shorter? Is it smaller? Do they have a ruler next to the bite marks in the picture, which the one I saw did not? Yes, it's speculation, and you're asking the jury to do investigating, which they're really not supposed to do, and create evidence in the jury room. I would not have ruled like this, but her argument, I think, is going to be, it's finite. There's actually a number that is that jaw, and it can be measured.
It's one of those things where lawyers and judges, we got to be realistic. We know that's what they're going to do. We know jurors are going to go back there and do it themselves. We know they're not supposed to. So even though they're not technically asking the jury to do that, you are. And when you called the dog Cleo, I had flashbacks to a couple of the trials we've had together. So I thought it'd be a fun time for a story. So my dad and I have tried cases together, obviously. And I'm more like my mom than my dad. I say that all the time. He is not stressed, not, OCD. He's like type A in his own way, but I am like my mom, neurotic and like wound tight, we'll say. And so 2 cases come to mind that we tried. One was in state court, one was in federal court. One, he said the wrong name of a witness the entire time, basically called her the wrong name, and closing argument said the wrong name the whole time. I'm sweating. I'm writing notes on the thing, like telling the name is Michelle, not Mary. I'm like handing notes. And we won, so it didn't matter. And then a federal court case, that was a Medicare fraud case. And half the trial he would say Medicare, half the trial he would say Medicaid. And it also didn't matter because we won that trial as well. Federal criminal case, which was a wild win. That was a wild win that we had. We've lost trials together too, so it's not like we win every time. But I remember those 2 because I was like sitting at the desk sweating the whole time, like the jury is going to think we're idiots. We're saying Medicaid instead of Medicare, and it didn't end up mattering.
And if you remember, I remember correctly, you in the middle of something, I was doing something, and you're pulling at my shirt or something to tell me, use this Medicare, not Medicaid. And I looked at the jury and I said, you know what I mean, right? I don't know if you remember that. And the jury goes, yeah, we know what you mean. So
I'm like sitting there, like, because when I'm trying a case, I'm doing 6 things at once. Like I'm listening to whoever's arguing or asking questions. I'm reading a depo, got the computer open with research if we need to, make an evidentiary argument or objection. And so I'm just sitting there sweating and cringing every time he says Medicaid when it's supposed to be Medicare. But that's just, it worked out.
I have a laid back attitude when I'm trying the case. So,
which is, I've always said, much better, much less stressful for a trial lawyer when they have a laid back attitude. But anyways, that was just a little story time. Okay. So anything about Garrett Wing you want to talk about? No surprises. Canoni's consistent, continuing to allow experts in. It's a pretty low bar.
Yes.
Anything you would add to that?
And I also think there is going to be some argument while they testify. I think we can prepare ourselves for how far they can go and how far, because I think both sides are going to try to slip in as much as they can with these experts. So I think there's going to be a lot of argument about what they can and can't say while they're actually testifying.
Yeah, I tend to agree.
Yeah.
All right. The next one is visual aids. Okay, so here's where I'm going to throw something at you you don't know about yet because I didn't send this to you. So both sides want to use visual aids during opening statements. Neither side objects. What are your thoughts to that? That's kind of weird. Like, why in the world would they not allow visual aids? But I guess they have to ask the judge first here, even if it's going to come into evidence. Like everybody knows it's going to come into evidence. Did you have any thoughts about their discussions on that? And what goes back to a prior hearing as well.
Well, the judge also said, I don't care if you guys agree or not. I still want to see them, and I still want to approve the visual aids. So, there's going to be a third party looking at them. I think what they both are thinking to themselves is, I want to go crazy. So if I want to go crazy, let them go crazy with these visual aids. I mean, I just don't think, I think they're just sitting around saying, I want to use them. You want to use them. Let's use them.
I agree. I think that's what they're saying. But from everything I've heard and seen, the defense wants to show one picture. Yes. One picture and one picture alone. And I guessed in my last video that it was John O'Keefe's injuries to his arms. That has seemingly been confirmed by the Commonwealth's newest motion they filed today. So let me ask you about this.
Okay.
Commonwealth filed a motion to exclude the defense in opening statement to mention not just the third party culprits. We know they're not allowed to name them in opening statements. We already know that. But they want to say that the defense can't even argue that anybody or anything, animal or person inside of 34 Fairview could have caused those injuries, to include, right? Because it would have to include this, that the cops did such a bad investigation, they didn't even knock on the door to see if there was a dog inside or ask if anybody inside did this. They wouldn't be able to do that because they don't want them to be able to say anything about the people inside 34 Fairview potentially causing the injuries to John O'Keefe's arms. I think this is something we can all agree on. Moms deserve the absolute best. And on Mother's Day, you get the best flowers from 1-800-Flowers.com. Every time I've ever ordered from 1-800-Flowers.com, my wife and my mom are blown away. The flowers are great and the service is exceptional. I'm always surprised how they can ship the flowers in this quantity, this many people, and have the quality still stay what it is. So this year, I'm pumped for this very timely partnership with 1-800-Flowers.com right before Mother's Day to make it oh so sweet. And right now, when you order 1 dozen roses, they'll double it to 2 dozen, free, twice the beauty, twice the love at no extra cost. So don't wait, because bouquets are selling fast. Lock in your order today and give moms their flowers. To claim your double your roses offer, go to 1-800-Flowers.com/LYK. That's 1-800-Flowers.com/LYK.
Well, I can tell you again, this is just my impression. I think the state is struggling. I think the Commonwealth is struggling on this. I think they're having a tough time preparing a prosecution because there are so many potential landmines for them, and that they really don't know their own theory. That's it. Do they attack third parties and exclude third parties? Do they try to defend this investigation as being a good investigation, or do they just say to themselves, let's just throw it on the table and tell the jury this was a bad investigation? I think they're having their problem. As we go through even this order, it'll become even more evident that they're having their own problem determining what direction they want to take. So they want to exclude in the opening statements these things until they hear the evidence, because they can't themselves prepare. They're having a tough time, I think, with the defense. I think the defense is really dancing around. Plus, remember, we've got some additional facts here, and we have a new person doing the opening for the defense. So they really can't depend on this opening being the same opening they heard in the first trial. Are they prepared for a new opening? Are they prepared for it? So by restricting their opening, and again, the defense says things at their own risk. So if they say something and they never come up with it during the course of the trial, the Commonwealth can beat them over the head with it at closing argument and say, do you remember when they said at opening they were going to do this, 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 and this, and it didn't happen? They can do that. So I really think it's the Commonwealth's paranoia here that they really don't know what's going on, and they'd rather hamstring the defense so that they can keep this close to the vest until trial, so they can see the evidence. I really think it's a Commonwealth problem.
I don't think the defense is worried one bit about that. But I just think that's totally inappropriate to continue to limit their defense. In any bad investigation case, you're going to say in opening, the evidence is going to show they didn't look here, they didn't search there, they didn't investigate other potential leads, they didn't even knock on the door. And I would even say they didn't knock on the door on 34 Fairview, 35 Fairview, 36 Fairview. Do any of them have dogs? Did any of them see what happened? Like, that's obviously going to be something in your opening statement, even if you don't specifically name the third-party culprit, because the third-party culprit defense allows you to go after those individuals and bring out more information about them than just to say the cops didn't even ask any of these people's questions. Those are two totally different arguments.
And does anybody question the fact that that's going to come into evidence? The fact that they didn't do this, that they didn't do that, and they didn't do this, and they didn't knock on a door, and they didn't look at this, and that's obviously going to come into evidence in anybody's theory. The judge has never restricted questions like that, so I don't see why there's any reason why the judge would restrict it in the road. And I don't think she will.
I was talking about this case with Pete and JD and Chase yesterday. We were sitting in Pete's office. Those are 3 other lawyers in our firm. Pete's our partner, and JD and Chase are 2 of our associates. And when I asked, I was like, Pete, Pete's a military guy who's officer in the Army. I was like, military guy, which is kind of akin to law enforcement, not the same thing. But if a guy was found dead on your lawn, you think cops would knock on your door? He's like, yeah. I was like, what would you say if they used red Solo cups to collect blood evidence? He's like, shut up. He's like, no, no, I swear that's this case. He doesn't know anything about this case. So I started telling about this case, and even George came up and started listening too. George, my nephew, and they were all like, seriously, that's crazy. Like none of them could believe it. We got into the Proctor text. I mean, you have an opportunity as the defense to shock the jury in opening statement to where they are literally falling out of their chairs. They know this is not normal. They know this is not how things are supposed to go without the conspiracy and the third party culprit. You don't even need all that in opening to make people fall out of their chairs with the investigation, the text messages, and now's a good time too, because we might as well talk about it because it's not specifically on this list of orders, and the sustained findings in the internal affairs report for Proctor. I'm going to bring those up on the screen real quick. What did you think about that? You said to me before we started, like you were surprised that a bigger deal wasn't made of that because initially the Commonwealth was fighting it, but now they took a little break. They went and talked, and they determined that they are going to allow the sustained findings. Do you think that would have happened in Florida or even federal court with, and again, we're also not positive what the sustained findings would be. Is it just guilty, guilty, guilty? Is it just where he says something like he failed to conform to the work standards? What is the sustained finding? Because if it is to include things like, and I'm going to read these and then get your reaction, Trooper Proctor, while assigned the lead investigator in homicide, sent derogatory, defamatory, disparaging, and otherwise inappropriate text messages about a suspect in the investigation. Trooper Proctor, while assigned as lead investigator, provided sensitive and or confidential information about a homicide victim, potential witnesses, and or potential investigative steps in the investigation to non-law enforcement personnel. Proctor also, as lead investigator, through his unprofessional and inappropriate conduct, here's the big kicker, created an image that he was biased in his dealings with a homicide suspect and or brought otherwise himself and the MSP into disrepute. And then finally, he consumed alcohol while on duty and not in the performance of a duty and while acting under specific orders from a supervisory member or proper authority. This occurred when he consumed alcohol while eating dinner on duty and then proceeded to operate his department-issued cruiser. So are they going to let him actually get into the facts, or are they just going to say this is a direct violation of Article 510(1) Class B violation? So tell me your thoughts.
Well, first off, it is a surprise to me that they're going to let the conclusions, whatever their conclusions are, actually come in. Proctor's termination, absolutely, that would come in. But the specific facts, because again, these are extrajudicial, these are it's hearsay. They're bringing this in, and they're not going to have any witness testify to the specifics in here, just that these things were said in a hearing where he was terminated. So in Florida, this wouldn't happen. In federal court, this wouldn't happen. But I guess in Massachusetts, and they're not fighting. Which is interesting is both sides eventually said, we're going to let the sustained findings in. So it's going to be interesting to see how far they're going to be allowed to go when they're cross-examining Proctor with regards to his termination and the findings.
Yeah, from my perspective, when I read this the first time, I was like, yeah, well, they're obviously not going to be able to get into these facts because it's almost like entering the province of the jury, letting the jury is going to make their own determination about whether Proctor did this stuff. The facts can come out at trial that he said this or said that, but the jury is going to have to determine if he's biased. This is somebody else determining Proctor to be biased, and it sounds like this is going to come in. So maybe we're confused about what the sustained findings are considered to be in Massachusetts through this trial board, but I'm pretty shocked that this was going to come in. I think it's great for the defense that it's going to come in. Maybe it's less than what we think, but definitely negative sustained findings are going to come in from the trial board about Proctor before this jury. And again, I would use them in opening statements.
And it's like you said, it could be that they're just going to be able to say, failed to conform to work standards established for a member, rank, title, position, just that kind of generic first sentence to show it's a violation of Article 5.8. Or they get into these specific facts. And boy, that would be really damaging. And again, I can see why Brennan in the Commonwealth are more worried about the second trial than they were the first.
Yeah. Okay. Let's get back to the order. All right. The next one we are going to talk about is Commonwealth's notice of intention to introduce extrajudicial statements of the defendant. The defendant doesn't object. No surprise there that those statements are going to come in. Even during opening, they're making sure they know exactly what they're going to play in opening. But to the extent the defendant objects to the Commonwealth's use of an independent reader for text messages between the defendant and John O'Keefe, the defendant should submit her objection in writing by close of business. So you and I haven't talked about this at all. I've kind of put my feelings and thoughts out there. What are your thoughts about the defense having an issue with them choosing a reader?
Well, I think the real objection is the dramatization of the reading. And they're worried that it won't be just a cold reading, just saying the words. There'll be inflections. There'll be all sorts. Plus, we've got a male and a female on some of these texts. Are they going to have a female reader read the female part, the male reader read the male part, or just have somebody read it? I don't, I don't think that a reader is really necessary. I think that in any case that I've had, normally it's the law enforcement agent that introduces the document who actually reads it. And I've never had an objection to that because normally law enforcement read it coldly. They don't read it with inflection. That's just not the way they do it. So I think this reader issue is a kind of a red herring. I don't think it makes any difference. And I just think, you're just bringing in people, wasting time, and it adds time to the case that you really don't need.
Yeah, the objection is to the dramatization, but the Commonwealth is assuring the defense they're not going to over dramatize it. But I think this, and even if we go back to the demonstrative aids during opening statement, this comes with some of the distrust between the two sides. And if I'm Judge Cannone, if I think about it, I think she's right about saying, I want to see everything you're going to use in opening so that you can't say, oh, we agreed to this, Judge, but they're playing this. Or they said they were going to use a slide and they used two slides. If you show it all to the judge, regardless of if there's a miscommunication between the lawyers, if the judge sees it, the judge allows it, everything's okay, it's above board. Similar to this, it's like, Judge, we don't trust them to pick a reader and not dramatize it. So have Guarino do it, which is the cop that did it the first trial.
And there are also two other points. One is, how about emphasis? All right, you've got to think what to the jury. Okay, detective gets off the stand and they bring a reader in to read it. So that emphasizes in the jury's mind this email. So it makes it even more stand out above other pieces of evidence because you're bringing a special person in. Even if it's not doesn't dramatize it, you're still bringing a special person in. So you're also still, delaying the trial and you're making it more dramatic, whether you like it or not. Also, again, the time that this takes to do, it drags the trial out. I don't really see the need for it, but I guess it's up to the prosecution or how they want to present the case, but I don't see a need for it.
Yeah, he also, and I want to get your thought on this, he also, as a form of presentation, sounds like he wants to put the officer up, get all the text messages into evidence, and then throughout the trial, call these readers at different points, meaning a cop testifies to what happened, he sits down. The reader comes and reads some text. Jennifer McCabe testifies about, where they were, whatever. Then he has a reader come and testify about the text before they got to the bar. Then a different witness comes up and testifies about, this vacation in Aruba. I know that's not actually coming in, but just as part of an example, then somebody comes and reads the text about Aruba. So he wants to kind of put them in throughout the case where they are relevant, which will add emphasis, but also I think is a better presentation if the judge allows it. What are your thoughts?
Judge may allow it. In majority of cases I've had, the judge hasn't allowed it. They say that, the jury is going to be able to do it. Let's bring it in, put all the evidence in at one time. And then, during your closing arguments, you can go ahead and take, okay, here's the email right before this event. Here's the email right before that event. So, not to, again, emphasize it and not to actually make the closing argument. Again, think about the delays. People don't realize, unless you've been in a trial, the delay in taking one witness off the stand, having him go out of the courtroom. Then you call another witness, having that witness come into the courtroom. You're still under oath, witness so and so, having them sit, having them read. Then they have to get off the stand, walk back out. Then the next witness has to come in. That all takes a lot of time. And this case is going to go on long enough. I wouldn't want to, if I was in the Commonwealth, I wouldn't want to drag it out longer than it is, because the longer you drag it out, the more they're going to forget your testimony at the beginning of the trial. So I think that if I was them, I'd rather save it for closing argument and put it all in context when I'm doing my closing argument, put those emails in context and do it that way. Because you can have a chart then, and you can have visual aids then to show where it fits into the timeline. I think that's the way I would do it. That's just me.
All right. The last one, we're going to take it in two parts because it's kind of similar. So the discovery, defendant's motion for specific discovery is allowed. Number 3 seeks any information, including any oral or written statements or communication of any witnesses suggesting a reluctance or a refusal to testify in connection with this case. Number 4 seeks any information, including any oral or written statements or communication of any witness wherein a witness suggested a reluctance or refusal to cooperate. Though it's a close call, and you got to love Judge Cannone doing that. I've never seen a judge do that this much. It's like, oh, this was a really close one. You lost, but you put up a good fight. Close call, arguably, this request is covered by Massachusetts Rule of Criminal Procedure 14B2, B1, or B3, and should be provided. Therefore, the Commonwealth needs to turn it all over within 1 week, or if a witness is going to testify within the week, because remember, we're going to start testimony on Tuesday after opening statements, you have to provide this information at least 1 day prior to the witness being called to testify.
All right. I know there's a lot of argument about her bias in this case, and her bias. This is one she could have gone against the defense, and she would have been okay. She would have been safe. I don't think any court would have reversed it, because there's no specification in Massachusetts Criminal Rule 14 that actually covers this. Unless you look at the broad, Brady or Giglio kind of arguments, or just the relevance arguments for the defense. She went with the defense on this. And I kind of, was surprised, because, she hasn't gone with the defense on a lot of the close calls. She did on this one. I think this one may end up being important. During cross-examination, they're going to ask these people, why is it you didn't want to cooperate with the state or Commonwealth? Why is it that you didn't want to testify? Now, problem with that question is it opens the door, because you don't know what the answer is going to be a lot of times. Sometimes it may be, well, because your client is so dangerous that I was scared of her.
Or witness intimidation. There's a lot of that in this case.
Or I was scared of podcasters putting my name.
That's what I'm saying. The allegations, I should say, of witness intimidation. There's a lot of allegations of that.
Right. So, you got to worry about the answer you're going to get. But I do think that this is going to be fruitful for cross-examination. I do think she threw them a bone on this one.
I think throughout these rulings, she threw the defense a bone. I shouldn't even say that. She was completely fair to me in these rulings. That's how I feel. If I was in front of this judge and these were the rulings, I would have been like, okay, great. Fair shake here at this trial. Mm-hmm. Okay. The last thing that's not included here is the discussion of ARCA continues, and the defense continues to argue they have turned everything over. They have just hired ARCA. There's a different order on ARCA, which we'll talk about what that is. But the defense continues to argue they've done everything. The feds just told them at the end of March they could hire him. They hired him immediately. The Commonwealth expert continues to update his report. ARCA needs to respond to that. They may have some additional findings. The Commonwealth wants to limit them to what they did the first time. The defense said there may be some more tests, and the judge said you have to turn over everything you have as far as, bias, payments, all that stuff, conversations by today, Friday, April 18th by 5 p.m. But just the suggestion and discussion and contemplation of future testing and things they may do by close of business April 21st. Not the results of all those testing, but just what are you thinking about doing in testing? Or if you have the results, turn them over. What did you think about the continued ARCA discussion? And Hank Brennan pounding the table saying, I told you this was going to happen, Judge, and this is exactly what's happening. They're going to give me evidence after trial starts. They're going to give me new findings after trial starts. How am I supposed to prepare my case?
Well, I kind of enjoy a little passion in the courtroom, and I enjoy a little drama. And he was passionate in his argument, and there are times where it's important to be passionate, so you really show, oh, I really believe this one, and you really argue it. So I don't fault him for being passionate. However, it is a situation where what's good for the goose is good for the gander. I mean, I think that is an accurate statement because they're both playing games here with how close to the vest they can hold their expert testimony, when they give discovery out, when they disclose things. And the defense has every right to respond to anything that the prosecution does or any reports the prosecution presents. uh, I think that one of the important things is that the ARCA experts are responding to a prosecution expert, and that's one of the things that they're really doing on this is reviewing the prosecution expert report. So, and people need to realize that a defendant has a particular right to a fair trial. And if you exclude something that's really significant to the defense, that, guilt, something that goes to guilt or innocence, if you're a judge and you exclude that, that's definitely going to be a reversal. Even if they violated a timeline, if the defense violated some timeline, unless you can show some prejudice to the prosecution. And if there is prejudice to prosecution, the remedy, I hate to say this, the remedy is a continuance. If the prosecution can't be ready, then let the prosecution move for a continuance. You can continue the trial to give them time to be ready. But you really, really run a danger if you're a judge if you exclude a piece of defense evidence, even if it's untimely. So the judge has to walk a line there, and Brennan knows that he's a defense lawyer. He realizes that he can't get away with stopping the defense from presenting a key piece of evidence, especially if it's responding to prosecution evidence. So I think what she did is right, and if Brennan doesn't like it, he can move to continue the trial.
Oh, they already have. They both tried to continue, and she said no.
Well,
But the reality is, every time, and you know this, and I know this, every time an expert updates their report or updates their opinion, the other side has the opportunity to respond, and they're going to have to respond to those new expert opinions. And the Commonwealth has continued to do that. And if you really look at the timeline the defense set out, it's pretty much in line with what the Commonwealth's doing. Number one. Number two, I really think that it's kind of like what you said at the beginning. I don't know if you said it was fear or they're just not prepared, but Dad, like let's talk about a insanity defense, right? You pretty much know what the I almost said Commonwealth, what the state's expert's going to say. They
right.
pretty much know what yours is going to say. We know once ours comes out with a report, they're going to respond and what that response is going to be. We know the problems in our case. We know the good parts. We know the problems in their case. We know the good parts. He's acting like he's got to completely change his case if they're allowed to respond to his expert. It's like,
Right.
they're going to, it's such a weird argument because we know as lawyers, their expert's going to say the opposite of whatever ours said. That's what was so shocking in the first trial. I was expecting the Commonwealth experts, accident reconstructionists, to be so much stronger and say so much more in opposition of ARCA, and it just never really happened. But I get it. You want to, raise hell and be like, oh, this is so unfair, Judge. I get lawyers doing that to a certain extent. But it really seems like he's nervous at what these ARCA guys are going to say in response to his expert.
Well, this second trial, and I know you follow it much closer than most people.
Mm.
But this second trial, I think, is going to be a lot different than the first trial. I
We're going to
think
find
there's
out.
going, excuse me?
We're going to find out. Yeah.
Yeah. But I really think it is the presentation, how it's presented, is going to be very different. And I think the Commonwealth is, again, struggling with their theory. I think the Commonwealth is struggling with how they're going to present their theory to the defense. And one of the struggles is they're worried about the ARCA. I mean, ARCA is going to really come across better in this second trial than they did in the first trial because they're going to be prepared. They're going to have
Mm.
time to be prepared for it. So it's going to come across better. And I think they're very scared of the ARCA testimony. And they're very scared and they don't know how to handle it in their opening statement. And trying to handle it in their opening statement, they don't know how the whatever amendments they're going to make to their report or whatever changes ARCA is going to make to the report based on their experts report. They don't know how that's going to come across or what ARCA is going to say. So again, it's all a matter of just fear and scrambling by the Commonwealth, and it's sad because the Commonwealth prosecutors have all the cards. I mean, they really should be the ones that control the pace of the trial and how a trial goes because they're the ones that have the burden of proof. And they're the ones that did all this investigation. And they really pretty much have an unlimited budget. So they're able to put this together. And the fact that they're still scrambling and they're still not really very clear on their theory is troubling. And it really is a troubling aspect of the Commonwealth's defense or
Yeah,
Commonwealth's presentation.
yeah, and I think that they kind of got what they asked for though, because they want to say these are defense experts, these are defense experts, these are defense experts, and when they're not defense experts and they're controlled by the FBI, while there's a lot of good that comes with that, and they're being unbiased, there's also a lot of limitations. Like the defense isn't like, well, what do you think about this? Or how can I use this? Or can you give me a little bit more here? Or can you do a little bit more testing here? But now that they're defense experts, officially retained by the defense, now the defense can ask them to do some specific things that are going to be really good for their case that they would not have been able to do before if they were trying to present them as independent witnesses. And that's what the Commonwealth has been pushing for the entire time. And now they got it.
Well, and the defense in the arguments that happened during the hearing, you saw that the limit of the expert testimony in the first trial was limited to what the federal government provided to ARCA in order for them to do their analysis. What the
Correct.
federal government provided was what was given to them in discovery by the defense because they subpoenaed the defendant's file and then they picked and chose. They didn't give everything. That's also an important point that came out at the hearing. The experts did not get everything from the federal prosecutors that were given to them by the defense. So now the defense is able to add to what ARCA got because they're able to give them everything, including things that were given to the prosecution expert that were not given to ARCA. Because apparently during cross-examination in the prosecution, when we were cross-examining ARCA, brought up all sorts of things ARCA did not look at in order to come up with their opinion. Now, ARCA is able to get everything that the prosecution has. They're not limited by what the federal prosecutors gave them. And now the ARCA can give better testimony, and that kills the cross examination by the Commonwealth because they're not going to be able to stand up there and say, well, you didn't look at this document. You didn't look at this photograph. You didn't look at this video. Now, ARCA is going to say, I did look at that photograph. I did look at that report. I did look at that video. And it's really going to hurt the cross examination of ARCA.
It's also going to hurt the impeachment because before they had them say, oh, no, I was not aware of this DNA or whatever it was they weren't aware of. And when you could have impeached them with that, now they can say, I wasn't aware of it. Now I am. And here's how I can answer that. And here's how I can fit that into the defense's case because now I am a defense expert, even though I think they're still going to say, what do you think? Because, maybe you think differently on this. I would still try to get out that all of their original testing was done when they were paid by somebody completely independent of the defense. Then the defense just hired them in March. I would try to get that in to still try them, make it seem like partially they were independent. When they came up with the conclusion that a car did not hit John O'Keefe, they had nothing to do with the defense at that point. Would you still try to get that in?
Well, I think one of the problems with that is you're got to be careful not to open the door if you're going to get that kind of cross
Open the
examination.
door to what?
Open the door to I think that, if you sit there and say you weren't, open the door to who did hire him.
Well, they
I
did
mean,
that in the first trial. They said it was an independent agency that was a third party, not connected with the Commonwealth or the defense. They did that in the first trial. She's going to allow that if the defense wants to present it that way.
right. But the problem is now you've got the defense hiring him, you've got
Correct.
the defense paying him. So, I think it's a different dynamic. I think it's going to
Sure, of
look
course.
different. It's going to look different to the jury.
Of
So I'm
course. But
not,
my
I'm
question
not
to you
too
is
worried about that.
my
I mean, I
question to you
wouldn't
is
be worried about it.
okay, my question though is specifically, would you still try to say they were independent when they did the original testing where they determined a car did not hit John O'Keefe, or would you just call them defense witnesses now?
Call them defense witnesses now.
Okay,
You,
I
you're
would not. I would still
um,
fully bring in that they were independent at the time.
I
I
think
think
you're
that's
always better if you own the things that are risks, because I think they found, if I remember right, didn't they find that the jury kind of assumed like the insurance company
mhm.
hired them, and that insurance company obviously is biased. So rather than have the jury speculate on who the original hires were, I think they're better off just going ahead and owning it. And because when you own something, it makes it a non-issue, and you just blow by.
And yeah, and the reason I disagree is the look on your face and my face when we heard somebody else hired these guys to do this testing is something you don't normally get as a defense attorney. So if there are jurors that, because maybe some jurors thought it was the insurance company, maybe some jurors thought it was the federal government, maybe some jurors thought they were truly independent. And how do you argue with that under the initial testing? That's how I would do it. There's disagreement though. People in the chat, feel free to agree with who you would. Okay, the last thing I want to talk about is Turtle Boy, aka Aiden
Yeah.
Carney, who is the blogger, YouTuber, journalist with, was it 16, 14 or 16 witness intimidation charges against him. There was that argument. Brennan wanted him to take the stand to plead the fifth. His lawyers didn't want him to. They wanted to assert it on his behalf. The judge ends up calling him to sidebar and ends up saying, I find that if he was going to be called to testify, he would invoke the fifth. The court finds that Mr. Carney does indeed have a valid basis to exercise his constitutional right. So he is going to be exempted from the sequestration order, except for the witnesses that are listed as victims in his cases. He will have to leave the courtroom for those witnesses. What did you think about that whole exchange where Brennan really wanted his moment to get Aiden Carney on the stand to plead the fifth?
Well, I think he knew it was a waste of time, but he had to try, I guess. Hope springs eternal, and I guess he was hoping that this guy would be so I don't want to say arrogant, but
you can say arrogant.
All right, so arrogant that he would want to take the stand and tell his story and go ahead and stand up there and just punch Brennan right in the nose. So
I think he would love to do that. I think he would love to. I mean, his personality is crude and rude and a complete jerk to people he hates and doesn't like. He's a nice guy to people he does like. He's definitely a smart guy. So I think he would love to try to outsmart Brennan on the stand and battle with him. So I'm sure he would have wanted to do that, but he's also smart enough to take the advice of counsel from what I've seen so far in his case.
Right. But again, that was Brennan's hope. Brennan's hope that he could get under this guy's skin enough that he's going to want to waive his Fifth Amendment right, get on there and battle with Brennan. This is his opportunity to go one-on-one with him. But, fortunately for him, he listened to his lawyer, and he is going to claim the fifth. I think that your listeners need to understand that they might want to ask the question, well, why doesn't Brennan put him on the stand to claim the Fifth Amendment? Why doesn't he do that so that the jury can see that this guy is going to claim the Fifth Amendment, and use that against the defense? And the rules are that if someone's going to claim the Fifth Amendment, you do not put him in front of the jury, because that would be unfair, because it wouldn't allow for any cross-examination. So you're putting him on there strictly for the fact he's claiming the fifth. The fifth is a constitutional right, and nothing negative should be inferred from claiming the Fifth Amendment. So that's why Brennan cannot put him on the stand to claim the Fifth Amendment in front of the jury. Even if he wanted to, he can't do it, and the law doesn't allow him to do it. So a lot of people might have wondered why, it's over now. Yes, it is over, because he is going to claim the fifth. His lawyer did make that representation to the court, and I think he was in the courtroom, if I remember right.
Yeah, he was. He was loving it.
He was sitting in the back of the courtroom.
Okay, so to end the podcast, because there's so many people that commented about this, and they say, well, everybody that pleads the fifth is guilty. They're admitting they committed a crime. It should be held against them. Look at all these people that didn't plead the fifth when they were, accused of things. What are your thoughts about that and the constitutional rights that connected to it, and what people can learn from this discussion? And some people that just do naturally think that, and it's understandable why you would think that, but that's not always the case. Why don't you give your thoughts on that?
Well, there's a lot of arguments on that. Number one, you're innocent and you're sitting there by yourself, and law enforcement comes and interviews you. The only people recording that interview, and it's not normally recorded, the only people that are going to interpret what you said are the law enforcement agents that are talking to you. So if you talk to that agent and you say something, there's a oh gosh, what's the movie? The lawyer movie. Anyway, they interviewed some guy and they said, "You, the guy at the gas station." He went, "What? I'm the guy at the gas station. What are you talking?" Okay. Well, the interpretation of law enforcement was that was a confession. You said, "I'm the guy at the gas station." All right, that's not what you meant, but that is what law enforcement interpreted it to be. So that's what they wrote down in their report as you made an admission. If you claim the Fifth Amendment, you're safe. You don't say anything, then you are safe. You didn't say nothing, you didn't say anything, and it couldn't be misinterpreted by anybody who listened to you. So that's number one. Number two, it is the burden of the prosecution to prove you guilty. So you have a right to have them prove you guilty beyond a reasonable doubt. If we don't do that, then that destroys our system of justice, and it puts the burden on an innocent person to prove their innocence. So you sit there and you claim your Fifth Amendment. That requires the state, the government, to prove you guilty beyond a reasonable doubt. It is a constitutional protection that protects you, innocent people, from being convicted or having to prove themselves innocent. That's the reason you have the Fifth Amendment. And so, these are all rights. And we did this because, going way back in England, you had no right to remain silent and they could beat a confession out of you. Well, today we don't beat confessions out of people because they have the right to the Fifth Amendment is protected in the Constitution. So there's a lot of reasons, a lot of good reasons for the Fifth Amendment.
Yeah. And I mean, even if you were to say, were you at the mall? Yeah, I was at the mall. Well, that's where the crime occurred. So now they have you locked in that you were at where the crime occurred, even if you didn't do it, right? It's just like there are pieces they can take, and we've seen it happen in cases. You give them something and they can blow it up into something much bigger, even if it's not an admission. And they're professionals. You're not, unless you have a professional with you. Listen to that professional.
Right.
So yeah, I mean, go ahead.
My cousin Vinny. That was the movie. I shot the clerk.
Yeah.
Yeah, that's right. I shot the clerk. Right. That was the confession. Right.
Yeah. Yeah. I mean, and it's these rights all fit together in a system, and the system has to work, and all these rights have to be protected in order for the system to work. All right. We are coming up on the trial. It's starting on Tuesday, tomorrow, the day you guys are all listening to this. So Dad, thank you for joining me. We're going to hopefully I got a couple other people lined up as well throughout the trial, but every week or a couple weeks, we're going to bring you on for a weekly recap, see what you thought about it. Even if it's not for the podcast, we'll have you on probably once a week just to get, week 1, week 2, week 3, what your thoughts are, what your highlights are, what's going well, what's going poorly, who's in the lead. We'll do all of that. So make sure you are listening and paying attention as we go. Thank you, everybody, for joining us. Throw your comments or your questions in the comment section for my dad specifically, because he'll be taking a look at those to answer as we go for the podcast. He always looks at the comments on the videos that he's on. So you guys can throw them in there, and we'll get those answered every time he comes on. Thanks for being here. Hit the like button. Make sure you subscribe. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.